Good timing.
Perfect timing. Someone rang just as we became live. So, hey, everyone, welcome. Mark Westcott here and Juanita Maiden. Welcome today.
Everybody.
Great to be chatting again. I was on a Zoom call with you up from Toowoomba a few hours ago, it seemed, and
Indeed.
here we are.
And you've made the I was going to say dash, but the nice steady drive back home.
Absolutely. Nice steady drive from Toowoomba back down to Southport today. Our topic is, Juanita, what do you want to talk about today?
Our topic today is the difference between enduring powers of attorney and advanced health directives, two documents that we prepare for our clients that sometimes can be confused.
Now you know everyone knows my first name now, don't they? Digby.
You've let the cat out of the bag.
Look, I'm just going to raise one other issue too, Juanita, is enduring powers of attorney versus standard powers of attorney, which I think is worth the explanation as well. Many people sort of may get confused between what's just a normal power of attorney and an enduring power of attorney. So,
just an old power of attorney. Sure, do you want me to explain that now?
Okay, let's do that.
Sure. So there's two types of powers of attorney. There's an enduring power of attorney and a general power of attorney. So a general power of attorney you might use if you're wanting to appoint someone to do a specific task. For example, I'm going overseas and I want Mark to sign a document for me specifically while I'm away. It might be a contract of sale if I get an offer on my house or something like that. Or it could just be for a period of time. I want Mark to be my attorney for 3 weeks while I'm away, having fun with girls. So that's a general power of attorney. Or it could be a company. A company will often appoint a person to act as their general power of attorney. So the key thing about this document is it goes for a period of time or finishes at the end of a certain task. If you lose capacity, it doesn't continue. So it's quite specific. An enduring power of attorney is the key word being enduring. So and we'll go into more of what the details of what it is, but basically when you lose capacity to make your own decisions, it endures. So it continues in that period of time for between when you've lost capacity to make your decisions and when you pass away. It endures over that time.
Okay, now that's a good distinction, isn't it? It's once you've actually passed away, it's no longer relevant, but specifically for that period where, for example, people who may have a car accident or an illness or something like that, where they no longer have capacity to make valid decisions. Am I being too broad with that?
No, that's right. But also it could come into play for our more elderly clients who, if they start experiencing dementia and go down that road, they're obviously unable to make their own decisions. So that's also a common period of life where it will be used. Of course, you mentioned it stops when you pass away. That's exactly right. And at that point in time is when your will is the relevant document. So some people get confused about that too. So enduring power of attorney lasts up to the point that you pass away, and after that is when your will kicks in.
Yeah, an enduring power of attorney, I mean, obviously these are important documents. If someone is reaching end of life, for example, they haven't yet passed away, but there's documents need to be signed, there's bills need to be paid, but the person's in hospital, unconscious, or unable to perform these sorts of duties. Obviously, that's because life can really become difficult, can't it, if you don't have an enduring power of attorney in place?
Oh, very, very much so. Especially in situations where you might not have an obvious next of kin. You might have, for example, if you don't have a spouse, you might have a number of children, and they might all be on the same level as such to be able to give authority as next of kin, but they might not agree. So just picking up on a few of those things that you mentioned, Mark, about the enduring power of attorney. Look, it's a really powerful document and becoming more and more important and relevant these days as people are living longer, as we've got a generation of wealth transfer. People are probably generally wealthier, have superannuation that lasts into their lifetime. So really, really important documents. The enduring power of attorney allows you to appoint someone to make decisions on your behalf for two types of matters. One is for financial matters, and the second is for personal and health matters. So we'll go into probably a little bit about what the examples of the different types are. You can have the same attorney for both, or you can choose a different attorney that you think is more suitable for financial and a different one that's more suitable for personal and health, for example. So financial matters, the sort of things that you would anticipate your attorney doing if they were acting as your attorney for financial matters, are things like paying your bills, updating your address on accounts, managing your bank account, paying your rent, that sort of thing. So, talking obviously money and administrative sort of issues. Obviously, you need someone who's savvy and who's responsible in both situations. Someone who's responsible, someone you trust, someone who's savvy to be able to do that. Are sort of the important features. We might have a client who has, for example, a business that they involve one of their family members with, a son or a daughter, or so maybe they might feel that it's suitable for that person to be making financial decisions, especially with respect to that part of their life, because they know more about it or they're more involved. So they're the sort of things we can work into an enduring power of attorney. Before I go on to that personal and health sort of side of things, there are also terms that we can put into an enduring power of attorney, and some that we recommend, even in the most standard of our enduring powers of attorney. So you may want, for example, your attorney to be able to deal with your superannuation trustee, which is becoming more and more important, as I said. And we can put certain controls around that so they can't go and change your nomination and end up, giving it to themselves. There's some good cases about that. But you can allow your attorney to renew your nomination if it lapses, for example, if you're with an industry fund. So that's an important clause. And you can sort of start seeing why a lot of people might think an enduring power of attorney is just a simple template, tick and flick. Well, these are the sort of things that your lawyer who's drafting your enduring power of attorney will be putting in, or should be putting in, or asking you about. So really important things that will help your attorney when you can't make your decisions.
Yeah, and I've actually watched firsthand as you've been speaking with clients about helping guide them to have specific clauses in their enduring power of attorneys. Whilst it is a form you can get from a government website or wherever it is you get them from, that's all very well, but I mean, you actually want to speak to a knowledgeable solicitor to actually get some independent advice. How's that cough going?
Yeah, it's good. It's good. And also, another reason why we don't recommend just the tick and flick download from the website is and this applies to both personal and health and financial. You would always recommend that you have a backup attorney. So, if you want to appoint your spouse as your attorney, we put a backup. It might be a child or a sibling, for example. So when that first person passes away, or if they can't act for some reason, you've got an automatic option B, and you don't need to go and do a new enduring power of attorney, or certainly in some cases it might be too late if by that stage. So that's also another example of why we will tailor an enduring power of attorney specifically to the client, rather than just printing out, downloading a form and ticking and flicking. Might move on to personal and health decisions. So that's sort of the financial part of things. Yeah, sure, Mark.
Okay, I thought I'd throw a question there.
Sure.
A lot of, dare I say, a lot of solicitors probably don't package up a will and an enduring power of attorney together. Clients go to them and they get their wills done, but it's not everybody that includes an enduring power of attorney as part of the packaging process, and an advanced health directive, which is the thing we'll be talking about a little bit later on. Would that be a fair thing to say? Many people go to their local lawyer and they just pick up a will, but miss these other important documents as well. Is that fair?
Yeah, I guess that certainly would be the case for many situations. But you'll find if you go to a experienced expertise, or estate planning lawyer, they'll always be addressing all of these suite of documents. So your will, your enduring power of attorney, your advanced health directive, your binding death benefit nomination for your super. And there may be some other ancillary documents that supplement your will, such as letters of wishes or guidance to your executors. So it's certainly not just a will. And this goes back to what we've spoken about many times, that we know the right questions to ask, and that's why you should go to an expert in estate planning to help put all those things in place.
Yeah, there's plenty of opportunities out there to just go and write a will. People, we've spoken a million times about people going and buying their own will kits from the newsagent and all that sort of stuff, and the pitfalls of that. So these valuable conversations we're having, Juanita, in regard to the things that you need, apart from your will and the advanced health directives, the enduring powers of attorney, very important parts of that. And before you go into the financial side, I just want to ask the question. The health side. What are some examples of where you've seen absolute tragedies where people haven't done this? Because such as even people in partnership, you might have a husband and wife in partnership, and if the husband, for example, is in a car accident and hasn't got capacity, what happens to the partnership? What happens to companies, trusts, if someone's a trustee of a trust and they lose capacity and you don't have an enduring power of attorney in place? What are the remedies for that?
Yeah, it's a good question. So I can think of 3 examples that jump to mind of things that can go wrong if you don't have this in place and you don't have the enduring power of attorney drafted correctly. The first one that can go wrong is superannuation. So I just spoke about having superannuation addressed in your enduring power of attorney. What can go wrong is if you have an industry fund, like many of us do, they'll usually lapse every 3 years. So if you lose capacity in between those 3 years and your nomination lapses, then you can't renew it. Potentially, your attorney may have obstacles dealing with the superannuation trustee unless it's specifically provided for. That's quite a usual occurrence. So your nomination might lapse, and who you wanted to get your super might not get your super, and there could be a dispute by warring family members over who will get your super simply because the nomination lapsed and your attorney couldn't do anything about it. So that's a real risk. I think specifically these days where there's substantial wealth in super, it's really important. Another thing we'll often see, but often with rural families, but also with families that are in businesses, is if a person has lost capacity and there's substantial financing arrangements with a bank put in place over rural properties, for example, the banks may be reluctant to deal with the attorney to change those financing arrangements unless the attorney is specifically allowed to do so in their enduring power of attorney. And although not a tragedy, I mean, that can just cause real practical issues for that period of time for the family potentially. Probably another example is where things can get quite messy, particularly is in a second marriage, perhaps. Just say a person loses capacity, they're in the hospital, someone needs to be giving the doctor decisions. We've seen instances where the adult children have one view and the second spouse might have another view. So there's warring family members over
as if that would happen.
Person on the operating table. There's no enduring power of attorney, and so obviously the medical practitioners are understandably wary because they don't want to do anything in a rush that would get themselves in trouble. So therein lies a huge practical problem, and we've certainly seen some nasty disputes around that sort of scenario.
Okay. No, thank you. I just want to so the audience could have some sort of example of some examples of how things can go wrong, and there's plenty of them, I know. So that's a good example with time constraint. So sorry, I interrupted you before you were moving on to the next type of.
That's fine. I would talk about this topic all day. So we've spoken now about financial matters. So the other part of your enduring power of attorney is appointing your attorney to make personal and health decisions for you. So the sort of decisions that this would be if you lost capacity, the more common ones are if you're in a coma, you're in hospital, you need or you've lost capacity as an elderly family member, you've got dementia. So your attorney will be making decisions about what medication you have, about giving doctors instructions. It even could come down to things like practically where you live. You're living in what retirement home, what personal items you need your money spent on, new clothes, that sort of thing. So just those real personal living, accommodation, health arrangements is what the attorney for personal and health reasons needs to be making decisions on.
And that's where I guess the confusion comes around with the Advanced Health Directive. Is that right? That's where people sort of get confused between the enduring power of attorney for health and the Advanced Health Directive. So it's good time to bring that one in.
Moving to that. So probably start off by saying if you only have an enduring power of attorney, that's okay. So your attorney can make those decisions for you. They have the power. That is a good start. So where we would recommend an advanced health directive to be put in place is in situations where you have, for example, really strong belief. Well, should I probably start by saying what it is? It's a document which specifically details medical and health wishes and instructions. And I've got one here, and I'll read out some examples shortly. But it goes into specific detail about what your wishes are as far as medical treatment, life resuscitation, life prolonging treatment, resuscitation, that sort of thing. So you can probably understand now why you might put that document in place. The most usual examples where I think it's really important is one when you have a really strong opinion on something. So if you are of the very strong view that you do not want to be resuscitated in a certain situation, then put it down in your advanced health directive so everyone knows, so the medical advisors know, so your family know. It's also useful in a situation where you think your attorneys or your family members might dispute over a decision. So you're in hospital, you need someone to be telling the doctor to make those sort of decisions, resuscitation or particular treatment. If you have a family member that, for example, is anti-resuscitation and one that is pro, and you know they're going to be at loggerheads, this just takes all that angst and confusion out of it. Your wishes are there on paper. Sometimes you might have joint attorneys. You might have appointed 2 or 3 children as your attorneys. This just, again, gives them that clarification, what your particular wishes are, and take any dispute they might have out of their hands.
Do you think it goes further than that, Juanita? And from recent personal experience, I mean, the fact that an advanced health directive is there, it actually takes the pressure off the children, doesn't it? Because
that was my third point, exactly. You can speak to that, Mark.
No. You keep going. You're doing a good job.
Yeah, as Mark alluded to, these aren't easy decisions, and you think you are going to be strong enough to make them, but when you're standing there in the moment being asked if you want to turn off a life support machine for your parent, it's a very emotional, very difficult and heavy decision to make. So excuse me, by having this document with that person has put down what their wishes are, you know what they are, everyone knows what they are, it takes that burden off the family member that has to make that decision. They don't feel burdened or guilty or have that carrying over them that they've made that decision. I think is really important and really helpful.
Look, absolutely. As as a child, if you're sitting there and your parent or your partner is in a situation where there's a opportunity to revive them for the 5th time or not revive them, that's a lot of pressure on a child, especially if there's one child there and the others aren't there, to make that decision. And that carries a lot of guilt too, because imagine, making that decision saying don't revive, mum or dad or whoever, you've made the choice to let your parent or the other person go, and that can weigh very heavily. And my thought on the Advanced Health Directive is that you're actually doing your children or your other partner, spouse, whatever, a huge favour in removing the guilt from them in regard to the decisions that need to be made. And also it gives, as you say, it gives people who've got a real opinion in regard to not wanting to be revived, let God's will go, so to speak. Don't make me sit here for another 6 months on life support system. It just takes away all the pressure and makes it very clear to those left behind in regard to what you'd want to happen, without putting pressure on children to make that decision at the time. And as I say, that's very guilt-ridden choice when the time comes.
Yeah, absolutely. And it might be useful for me to read a couple of the questions that are contained in the Advanced Health Directive. Try not to cough in the microphone.
I'm actually really glad to see that people still get colds these days, and it's okay.
And look, I'll just say before I start reading, some of these questions are confronting. So, warning if it is a little bit confronting for you. But I think it's important to give you a bit of context about the sort of things that you can include in your Advanced Health Directive. So the sort of questions we've got are, my major health conditions and concerns are, you can fill in the box. These things are important to me if I lose capacity. So what living well means to you now and in the future, such as where you live and who you socialise with. These things worry me about my future. These are the cultural, religious or spiritual values that I would like to be considered in my health care. I prefer these people to be involved in discussions about my health and these people not to be. So that can be a pretty powerful thing for you to put down if you're worried about something. Other questions such as, I give the following directions about life-sustaining treatment. So what I consent or refuse to as far as certain treatments go. I give the following directions about certain life-sustaining treatments such as CPR, assisted ventilation, antibiotics, artificial hydration, any other life-sustaining treatment. We found a lot of people are really have a real strong opinion on a lot of that stuff, so very important.
And this is a form you have to take to your doctor to get completed too, isn't it? So
absolutely.
Because a lot of people wouldn't understand. Not everyone understands what this actually necessarily means. So for some of us.
And it's a great idea that you do. So what happens is we prepare the document for you. You then take it away and fill in the document. So you go through the sections. You can sort of see that's what it looks like. You'll fill in the boxes, tick certain boxes. After you've done that, then you must go see your doctor. So it can be your GP or your treating doctor. They have to sit down with you and make sure that you understand everything that you've just signed to. So that's obviously very important. Once they're satisfied that you understand the nature and effect of what you have signed or what you have filled in, they will then sign the document themselves and complete it. Then you must sign the document after. So that's right, that's the doctor's certificate right there. So the doctor's specifically signing that they are a doctor, that they've discussed it with you, that you appear to have capacity at the time to make the document and understand the nature and effect of the document and the terminology in the document. There's a few types of people that can't sign that. So your attorney, a relation or a beneficiary under your will, they'll fill out the details and then sign that.
Very good. The directions there on that page about blood transfusions. I mean, for some people it's a religious. Sorry to be putting you through this today, Juanita.
No, it's all good. Sorry, everyone hearing my coughing in the ear.
No, that's right. But for some people, it's a religious issue, isn't it? Blood transfusions and
absolutely,
and so on. So or not, and you can make that choice there whether you want a transfusion or not. So yeah, it's a confronting document. As I say, mine just turned up today, and that you sent down to me, and so yeah, I'm making an appointment with my doctor to go and get that completed.
And so after the doctor signed it, that's when you then must sign it, and you must sign it in the presence of a qualified witness. So often our client will come back in and sign it in front of us. You have to be a JP or a commissioner for declarations or a solicitor, and then that's the completion of the document. And obviously, it's a good idea to give copies of these documents to your attorneys and to your doctor. If you live in a retirement village, they'd often want a copy as well. Sometimes for the enduring power of attorney, sometimes your bank might want a copy to have on file. or you're a financial planner. So they're the sort of people that would be interested in those documents once they've been completed. I'll probably also just add, in the Advanced Health Directive document, there is a section where you can appoint attorneys.
Okay.
We choose to do a separate enduring power of attorney and then cross that section out in the Advanced Health Directive. And the reason for that is what I said before about we prefer to draft specific terms that are tailored to the individual in our enduring power of attorney. You can't do that in this Advanced Health Directive document. So that's why, even though you have that option, if you look at the document, we would recommend doing an enduring power of attorney, and then if you would like to put one in place, an Advanced Health Directive to supplement that enduring power of attorney.
Yeah. Okay. Very, very wise points. And I guess it just keeps coming back to the fact, Juanita, that in regard to all these issues, you really need to seek professional advice and help. I mean, it's all very well to download things from government websites and so on, but I mean, the truth is you need to dig a bit deeper and get better advice in regard to your own personal situation. And you guys at Murdoch Lawyers do a great job in helping clients with this. You included always the opportunity for the enduring power of attorney when you're doing estate planning with people. That's one of the key things that you make sure is done, and more people now are asking for the Advanced Health Directives as well. So it's part of a good plan, and it's part of a thorough plan is to look at all the documentation you need when you're doing your estate planning, not just the will. So so anything else you'd like to finish off with, or?
I think we've covered everything. Just really important. You know, often people just think a will, just estate planning is just a will, but these documents are just super important to also have in place, particularly the enduring power of attorney. Because also, I'll just finish off by saying, once you lose capacity, it's too late.
Yep.
So you need to put it in place while you're healthy, while you're able to, and while you understand.
Like you're young and still physically fit like we are. That's what you're trying to say.
That is when you need to.
No, that's right. Juanita, once again, thank you. Thanks very much for your time today. Very interesting topic as usual. And those watching, we look forward to seeing you in a fortnight. Thanks again for your time. See ya.
Everyone, thank you.